It's my great pleasure today to have our talk co-hosted here with Mauer, and thank Donna and everyone here on that and helping with all of this. I think it's a nice collaboration, and we brought in a suitably distinguished speaker in Peter Swire. I'm not going to go through all of his credentials, but just mention a few high points. The holder chair of law and ethics at the Georgia Tech Scheller College of Business, a senior fellow with the Future of Privacy Forum, and then I think very notably under President Clinton, the chief counselor for privacy and the first person with U.S. government-wide responsibility for privacy policy. And a number of other credentials that I won't go through, but I'll just ask you at this point to please join me in welcoming Peter and look forward to your talk.
Hi, everybody. Let me just do a sound check. Is this okay in the back of the room? Can you hear me okay? Okay, that's great. It's a pleasure to be here today. I first came to Indiana in 1990 when I was on the road to trying to become a law professor, and it's been a place that I've looked to as a great Big Ten school for many years. I taught at Ohio State for 16 years, which is a different shade of red. But the land-grant universities and the service they provide is something that's really important to our states. I wanted to just I'm going to ask whether your background's mostly in law, mostly in technology, or mostly something else, just to get a sense of. So it's mostly in law, would you say? That's a little less than half. Mostly in technology, about half the room, maybe a little more. Mostly something else. Okay, good. This paper is going to be about surveillance, including surveillance under Section 702 of FISA. It's going to be more on the law side, but I think it'll be accessible to people with a tech background. Later this afternoon, with Scott Shackelford's group, I'm going to be giving a talk on so the tech people, you know, the OSI stack, the 7 layers of the OSI stack, right? Now, if you're tech people, yeah. I'm doing a project that's going to talk about the non-code layers of the stack and how that applies to organizations and governments and international issues for cybersecurity. So that'll be more the cybersecurity technology side of myself. And I do have an appointment with the College of Computing now too at Georgia Tech. So I try to move between these worlds to some extent. This project is called Understanding Why Citizenship Matters for Surveillance Rules. It's co-authored with one of my colleagues at Georgia Tech named Jesse Wu. And it starts with an issue. So is it lawful and is it a good idea, normatively defensible, to have different surveillance rules for a nation's own citizens and for citizens of other countries? In other words, can we discriminate based on nationality? And the paper takes on this topic, which hasn't been addressed very clearly before, and we say yes. Now, there's people who have very different views. So as a matter of positive law, we have the UN Special Rapporteur for Privacy. His name's Joseph Kenataki, a distinguished professor. And he says U.S. laws and practices permitting a lower level of privacy protection for people who are not USA citizens or residents are incompatible with the U.S.'s obligation under international law. In other words, they're saying the whole FISA structure is illegal under international law. And we're going to call that legal approach a universalist legal position. People are people, don't discriminate based on nationality. And as a normative idea, Martha Nussbaum is somebody associated with this sort of broader theme of cosmopolitanism. And she says, if we really do believe that all human beings are created equal and endowed with certain inalienable rights, we are morally required to think about what that conception requires with us, for us and the rest of the world. And more specifically, the universalists, the people who think no discrimination, often make a normative argument. And they favor the same treatment of all nations. So Kenataki, again, the UN Special Rapporteur, who's having conferences all over the world and really pushing this, says, especially when it comes to surveillance carried out on the internet, think Snowden, all that surveillance, privacy should not be a right that depends on the passport of your pocket. And that normative view is the cosmopolitan, people are people, inalienable rights, and they should be protected the same. He's from Malta. He doesn't want people from Malta treated worse than people from the United States when it comes to surveillance. And there's a sympathy for that. You know, we're here in the middle of the United States, but if you were subject to lots of surveillance from other countries and they were targeting you because you're an American, you might not really like that. So the outline of the paper is, we say that the lawfulness and the legitimacy of these different rules for what we call target nationality is an important but overlooked issue. And we'll talk about the area of mutual legal assistance, where I'm doing a lot of research right now, and about FISA. We're going to go through the positive law, and we're going to see that both US and German and other democracies actually have very different rules based on target nationality. So what is shows that Germany, even, which has often pushed the universalist idea, has very different rules for German citizens and non-Germans. And then we're going to have something that's really developed, I think, new in this paper. I haven't been able to find anywhere, and I've given it one other place, and they hadn't. We're going to say there's two different normative justifications. So pick whether you like contractarianism or utilitarianism. We win both ways, an argument, the alternative by a lawyer. So social contract theory. And if you think of Locke and those people, the basic idea is there's a difference about law within the social contract. That's where the US Constitution applies, and the state of nature. And we're going to treat foreign enemies at least differently from our citizens. There's going to be different rules when you're at war than when you're back at home in peacetime. And a different kind of argument is the utilitarian argument about outcomes. And we say that stricter rules for domestic surveillance is crucial to preserving democracy and the rule of law. Who's in favor of democracy and the rule of law? Only half the room raised their hand. What? I hope to convince you that democracy is worth preserving at the end of the hour. Okay, and the fact here is, think about what the Watergate break-in is. It was a break-in to the opposition political party. It was secret criminals for the president breaking into the opposition political party. We have a lot of rules to try to stop that kind of stifling of domestic opposition, and that's the reason to be extra careful when it comes to domestic surveillance, because that's what's going to keep democracy. So it's based on where the Constitution applies, it's based on keeping democracy. For those reasons, the paper says we should have different rules. So that's the outline. And if we have questions as we go along, clarification, please don't hesitate. Terminology in the paper, we use the term target nationality. It's the nationality of the person who's the target of surveillance. Are you a US person? Are you a French person? Whatever. We have different rules, and we come up with, we call it citizens and near citizens, people with a strong connection, let's say, to the United States. US persons, which is a legal term in our thing. Are people familiar with US persons in FISA? Have people heard of Section 702 before this talk before? PRISM, upstream, sort of, not really? Okay, sort of, not really. So in FISA, which is Foreign Intelligence Surveillance, that's our system for looking at Russian agents, for instance, in the United States. It includes, US persons includes US citizens. We're stricter on that. And we're stricter for people with a green card, permanent resident aliens. Also, the US Constitution generally applies to people who happen to be in the United States. I had a student last night ask me, hey, you know, I'm a Indian national. When I'm in the United States, does the Fourth Amendment stop the police from breaking into my dorm room? And the answer is yes. So if you're in the United States, you get constitutional protection. Those are citizens and near citizens with a strong tie to the nation. Everyone else is a non-resident. They don't have a strong connection. They're not here in the United States. Those are non-residents. And our claim in the paper is it's lawful and normatively defensible to apply different rules based on target nationality. That's the claim for the paper. So one slide on mutual legal assistance. We have a project at Georgia Tech on cross-border access to data. And the basic, which is the URL, basic thesis of that project, which we have tons of stuff up on for the last 2.5 years, is that we're facing what's now called we call the globalization of criminal evidence. And the way to think about that is, routinely you have evidence for a criminal case that might be emails or Facebook posts or other kind of communications. And they're often stored in the cloud, right? Isn't most of your phone stuff stored in the cloud? It's often stored in a different country. So if the police want to investigate a local crime in Bloomington, your stuff might have bounced through Europe or Asia or who knows what. So when we think about what the rules are going to be for different countries getting the data, let's think about the United Kingdom, who wants evidence held by Google, some other US cloud provider. If it's data about UK citizens, we sort of understand why they think maybe they have a shot at that. If it's data on a crime committed in the UK by persons resident in the UK, we see why the UK has a pretty strong claim, hey, Google, give us this data. But if it's somebody who lives in India, who's never been to the UK, we might say to Google might say, what the heck are you asking for this for? This isn't your email. You don't have some basis for fishing around in that. You know, stick to your people and don't go after people from other countries. And so most of the reform proposals dealing with all these cross-border flows treat the latter differently. There's a weaker EU claim. The UK doesn't really have jurisdiction probably over that person. And even if they do, they probably don't have a strong choice of law argument when they select what rule to apply. And so we would expect for these sort of law enforcement investigations going cross-border that there's different treatment based on target nationality. In this situation, the UK gets greater access to UK persons. In a minute, we're going to see maybe the UK gets greater access to non-UK persons. But the point being that we have an important evolving area of law where the nationality of the target matters. Here's FISA, Foreign Intelligence Surveillance Act. So since FISA was set up in 1978, there's been different legal treatment for US persons, citizens and residents, and for non-US persons. This is FISA is for surveillance done in the United States in order to go after foreign intelligence goals, agents of a foreign power. Section 702 of FISA, the PRISM and Upstream programs, were passed in 2008 and provides less strict rules for surveillance, easier surveillance, if you're not targeting a US person and you're not targeting a person in the US. So if there's somebody over in the other country who's not a US person, we're doing a communication between Iraq and Syria, it's easier to grab the data about Iraq to Syria communication. But if it's back home and it's a US person, or if it's a US person in Iraq, they have to be more careful. So the basic point of the structure is we have clear law that says we're stricter protections for US persons, not as strict for foreign people who are overseas, which violates Joe Kanataki, UN reporter's views of how the world should operate. Now, this became very public in Europe and other places after Snowden disclosed the PRISM program and another program called Upstream. And so in Europe, which has strict privacy rules, they've been going nuts for 5 years about Section 702. They think it's terrible, really bad, Europeans being treated as less than full citizens and getting to be the target of surveillance. So there's anger at the US surveillance system by the NSA. And this anger was quoted, and I think it's fair to say it was important to the European Court of Justice decision in 2015. Have people heard of the safe harbor that got struck down in Schrems versus Facebook? Sort of a quarter of the room. The follow-up decision on Schrems versus Facebook is just went public this week, will be announced on Tuesday this week. So look for your newspapers to see if they're going to cut off more data flows between Europe and the United States. But the concern for their Supreme Court is that there's too much NSA surveillance of EU persons, and they might drastically affect data flows between the US and Europe because of it. And if the European Court came to the view that the US is discriminating here against EU persons, that might be a reason for cutting off data flows between Europe and the United States. So if the UN reporter's position happened and was adopted by the EU court, we could see a big disruption of global data flows. If it turns out our view is correct and we can defend a two-tier system, then they wouldn't have the same basis for cutting off data flows. So that's a reason to get this paper out and maybe make it convincing if we can, so we don't disrupt global data flows. I'd rather not disrupt global data flows. But let's try to have a good argument. Okay, so we see that these are current issues. Target nationality is very much in debate. Part two of the paper is, what about the lawfulness? Is it, as a matter of law, okay to treat different countries differently? And we'll talk about the universalist legal position. They think it's a bad idea. Then we'll look at US law. It allows two-tier treatment, and the German and other national laws allowing two-tier treatment. The universalist position starts with the International Covenant on Civil and Political Rights, which the US and many other countries have adopted. It says no one shall be subjected to unlawful or arbitrary interference with his privacy, family, home, or correspondence. Think of it as sort of like the Fourth Amendment. You should be securing your person's papers and effects. The intent of the drafters, say the universalists, is to prevent discrimination based on language in the treaty called national or social origin. So there's this UN thing that the US has signed, and Kanataki thinks the US is bound in that way. They point to other legal sources that are in the paper, the European Convention on Human Rights, the European Union Charter, which is binding law under the Lisbon Treaty for Europe, and the German Constitution. So the paper goes through these other sources of law for why it might be illegal to have a two-tier treatment. But the U.S. positive law supports a distinction, supports a two-tier approach. The ICCPR, that treaty I just said, the text supports the view that there is no extraterritoriality. The consistent U.S. government position since the thing was drafted and amended is on that side. Eleanor Roosevelt said it wasn't extraterritorial, and she's a hero to people in the civil rights community. And so just as a matter of lawyering, my view is similar to the U.S. government's view, which is the ICCPR does not apply. There's a Supreme Court case from post-World War II called Eisentrager that supports the idea that the U.S. constitutional protections don't apply to non-U.S. people outside the United States. The Fourth Amendment case of Verdugo-Urquidez supports the view that Fourth Amendment protections are different for U.S. persons abroad than for non-U.S. persons abroad. And we have all the activities under FISA and the court, the Foreign Intelligence Surveillance Court. And since, as we said, since the start of FISA, there have been different rules based on target nationality. And we have very recent court approval for this. There was a court earlier this year, the FISA court earlier this year, had a 702 decision about what's called about collection. So if Peter or Swire is the target, if it's about Peter rather than to and from Peter, if it's about Peter, can you do the collection? And for the about case, the court said it violated the Fourth Amendment the way it was being implemented, that there were too many American communications that were being intercepted. The Fourth Amendment is more protective for U.S. persons. We're going to apply it more strictly. So you could have about collection for foreigners, but you can't have about collection for U.S. persons. And they stopped the program. Okay, so there's plenty of U.S. law that suggests two-tier is okay. Well, same thing for Germany, it turns out. So Germany, post-Nazis, post-Stasi, worried about surveillance, is usually seen as the strictest country in Europe on privacy. They were pushing for the ICCPR to get reformed a few years ago. So they thought this was neat. They wanted a one-tier system. There's a senior German academic who has an argument about the German constitution, says it has to be a one-tier system. But when you actually look at the German surveillance law, it's just like 702. And one of the parts of doing this scholarship is you get claims from Europeans sometimes criticizing the United States as the worst people ever. We do really, really bad things. And one of my jobs for the last bunch of years has been to point out, by the way, that's your law too. So in this Facebook and Trends case that's coming out on Tuesday, I wrote a 300-page testimony. Go read it tonight. Which basically, the summary of the testimony as an independent expert for the court is that the U.S. surveillance legal protections are stricter than anything they have in Europe. So if they say we're inadequate, they're worse. And maybe you should notice that before you just say the U.S. is terrible. So that's that testimony. So in this case, we're saying, the Germans often say 702 is terrible, but the German surveillance law has special prohibitions on targeting German citizens in the law, statutory law. It has more oversight if the communication is destined for Germany than other kinds of communications. And the German law has broader powers to go after foreign to foreign, Iraq to Syria communications, just like 702. And when you look at the universalist advocates, they say, oh, and sort of too bad, but France does the same thing. And the Five Eyes, which is UK, Canada, New Zealand, Australia, and the US, all do the same thing. And one of the best advocates for the universalist view has admitted neither EU law nor the European Convention on Human Rights appears to constrain EU member states' surveillance of foreign nationals beyond their border. So if you take the experts who think that this stuff's terrible, they end up saying, oh, we do recognize that the other democracies have done the same thing. So if they're going to get really upset about the U.S. approach, notice that the other democracies have made the same choice. And I think there's good reasons for that. And we're going to go into those reasons in a minute. Any questions so far? So far, the view is Europe's doing it, the U.S. is doing it. It's well established. Don't be shocked if this is the way it's always been. Okay, part 3 is the principled case, I hope, for stricter surveillance protections for citizens and near citizens. And we're going to do social contracting, utilitarian. The claim is this paper doesn't try to specify exactly the context where surveillance rules should vary. It doesn't say how different they should be, but the focus is on developing a normative argument for ever having different rules. We're saying it's not invidious discrimination that's presumptively terrible, when you have different rules. Two-tier makes sense normatively. What you want is a two-tier system. Here's the social contract theory. So John Locke and other social contract theorists, but we quote Locke in detail, makes a big difference between those of us who've entered into a constitution, a social contract. We get rights and responsibilities. We get to be drafted into the military, and we get the Fourth Amendment. And the state of nature, those things out there where people haven't agreed to be part of our community, and they don't get all these constitutional protections. And to see how this is, let's think about whether we should have full US legal protections like the Fourth Amendment during the state of war. So when I was working on an earlier round of work in this area, one of my sons was a US military officer in Kandahar doing motorized infantry patrols across Kandahar. And I was worried about IEDs, as you would be if you were a parent or family member, something like that. I wanted to surveil the heck out of IEDs. I didn't want there to be a Fourth Amendment warrant procedure before we found out if signals intelligence was happening. I wanted the US Army to have awesome surveillance capabilities so the IEDs wouldn't go. That was selfish, but by the way, that's what happens in wartime. You don't want your people getting killed. Also, you can't even have a judicial mechanism to apply Fourth Amendment standards in the war zone. There's no judge with jurisdiction over Kandahar, and the Northern District of Georgia doesn't have jurisdiction in Kandahar. So we literally have no way to apply the same rules, and it would be nuts to be that restrictive during wartime. Okay. Two-tier standards: at home, domestically U.S. person stricter. In the middle of Kandahar, not so strict. Do surveillance, go do it. Well, you start with that easy case or extreme case. And then you think about, it's not just state of war. What about foreign adversaries? If we think Russia and Crimea is doing something wrong when they went into the Crimea, do we have to apply all the same standards before we do surveillance there? That would really undermine our national security efforts. We do intelligence against foreign adversaries. Well, we also do intelligence about foreign affairs. We have allies, and we've caught spies from those allies. And by the way, we've spied on those allies. We got caught spying on Merkel. Israel got caught spying on us with Jonathan Pollard. So there's a lot of reasons you keep an eye on foreign affairs, even for your friends. And there's some legal rules from the last administration called PPD 28, which says in general we're going to treat non-US and US similar, but it says there's national security limits. So we try to treat people under the same standard, but we reserve the right to do it differently when we need to. And the FISA rules, which is about agents of foreign powers working for other countries, the FISA rules are more permissive. And it's only when you get to domestic law enforcement, you're really in full Fourth Amendment land. And that's where the rules are strictest, probable cause warrants for the judge and all that kind of stuff. So we see this spectrum. I'm working on pretty graphics that we don't have yet, a nice spectrum where domestic law enforcement, same standards for everybody, is the exception in a dangerous world where we have lots of other goals and lots of other things we need to do in foreign affairs. So the conclusion from this is social contract theory, how we think about a constitution, and our national security interests, and pervasive historical practice, because people have been spying since at least Sun Tzu, who said really do it a lot. All of that leads us to view this as normal and justifiable to protect ourselves. And we're not going to tie both hands behind our back and treat everything like a local police thing. We're going to have more surveillance overseas against dangerous parts of the world. That's this slide. I'm going to take a sip of water and then pontificate some more. So when I was doing graduate work in political theory, it was sort of, you could be a social contract person or you could be utilitarian based on consequences, not based on rights. And here's some other reasons that support different rules. Well, Locke and Madison and lots of other people since then think there needs to be really good checks and balances against tyranny. That's the Federalist Papers. That's core to the U.S. system of government. So in the paper, this is our attempt to summarize why. Unfettered surveillance domestically presents grave threats to the system of checks and balances. Unfettered surveillance, if it were done by the current government or any current government, the government can surveil and take action against political opponents. The government can go against the free press. It can go against judges. It can go against senators and congressmen. And it goes to anyone else who stands against unilateral government power. So we live in a world where there's very powerful surveillance tools that exist for the FBI domestically. If you unleashed all of that against domestic opposition, you're running a terrible risk. And the US Supreme Court has agreed. So in an early 1970s case during the Watergate debates, the Supreme Court said, history abundantly documents the tendency of government, however benevolent and benign its motive, to view with suspicion those who most fervently dispute its policies. The Fourth Amendment protections become more necessary when the targets of official surveillance may be those suspected of unorthodoxy in their political views. So deep in the constitutional structures and awareness, the government's tempted to go after their opponents. And in awareness, we have to bolster the protections at exactly that moment. So utilitarianism is about outcomes or pragmatism, because avoiding this bad outcome helps to prevent a descent into tyranny. So constitutional scholar David Gray at Maryland says the Fourth Amendment is linked to the collective projects of self-government. Fourth Amendment is limits on search by the government. It's a collective project, not just an individual right. Here's some collective outcomes. Let's protect the rule of law. Let's minimize the risk that democracy will slip toward authoritarianism. And so our argument, it turns out, supports the view that individual rights will be better protected where the rules against domestic surveillance are especially strict. So if you're a rights person and you want to be with Joe Kanataki for the best darn protection of individual rights and the privacy that you can, then we're saying you should love stricter rules against domestic surveillance, because that's how we're going to keep democracy and the rule of law. So properly understood, we're rights enhancing with this approach, even though it seems like we're undermining the rights of people who aren't Americans. Here's some supporting quotes. Frank Church, the Church Commission. People have heard of the Church Commission after Watergate. That's sort of out there in your history. Many of you, okay. I know that the capacity is there to make tyranny total in America. He said this after doing the huge investigation that the NSA and the CIA and the US Army were doing domestically. We must see to it that this agency and all agencies that possess this technology operate within the law and under proper supervision. They created the Senate and House Intelligence Committees, for instance, so that we never cross over that abyss. That's the abyss from which there is no return. Because once you've lost and the authoritarians put themselves in power, you stop having elections. And that's the abyss we're trying to avoid. Here's a quote from the review group. President Obama, after Snowden, created a 5-person group called the Review Group on Intelligence and Communications Technology, often called the NSA Review Group. I was one of the 5 people on that group, along with Cass Sunstein and Richard Clark and Michael Morrell and Jeffrey Stone. So in that report, there was a sort of preview of this argument. FISA's stricter limits, the Foreign Intelligence stricter limits on domestic surveillance, express not only a respect for individual privacy, but also and fundamentally a deep concern about potential government abuse within our own political system. The special protections for U.S. persons being defended in this 2013 report must therefore be understood as a critical safeguard of democratic accountability and effective self-government within the American political system. So that's an early sort of succinct version that's being thrown out into this argument. And the recent and not so recent history of surveillance shows a very strong theme of surveillance going after domestic political opposition. And this won't surprise you. Hitler, not so friendly to domestic political opposition. Stalin, the East German government Stasi, which was secret police in the communist era. That is a key role of secret police, to detect political opposition and clamp down on it. So if you are worried about secret police, if you think that's a bad thing, that's a sign of how authoritarians go after political opposition. Resisting secret police in some ways is saying we should have very strict limits against domestic surveillance. Recent history. I picked, there's more examples, but here's 3, ripped from the headlines. In Turkey, there's been a growth in domestic surveillance since Erdogan's come in over time. But after the failed coup a couple of years ago, they passed broad new powers for domestic surveillance, and there's been mass jailings of political opponents. And Turkey's well down the path towards not being as much of a democracy as it used to be. Russia under Putin, intimidation and reported murders of political appointments. They have a surveillance program called FORM. I was over in Russia on a mission, and we learned a lot about it. It requires their internet service providers to be able to conduct deep packet inspection to do surveillance, and a lot of that is targeted against political opponents. Venezuela, sad news this year, about even worse than it was before under Maduro. Domestic intelligence services target and jail political opposition. And the Patriotas Cooperantes is a group that's act as secret police in the communities to look for opponents. These are, for people who support democracy and human rights around the world, 3 sad stories, I think, in the last 10 years. And they clearly include stepped up intensive surveillance against domestic political people of opposition. So this isn't some theoretical thing that's limited to the Hitler example. This is things we see happening in places that were having elections that mattered and now don't seem as open to having elections that matter. Here's a variation on the same point. Domestic surveillance is also a potent tool against the free press. Authoritarian practice of surveillance and suppression of the free press is a key, the free press is a key check on executive power. And so we can do quickly the same. Countries, Turkey, we have a quote, now is the worst time for journalists in the last year or so. There's been jailing of journalists, forcing people to resign from the media, raiding outlets that criticize the government. In Russia, same story. In Venezuela, same story. And so having protections against surveillance of the press and interference with it, having protections for the opposition political party is central to the project of keeping democracy going. And how do you do that? There's no guarantees in life. People can do crazy things and vote for crazy people, but these are checks and balances against the executive locally taking power in a way that they don't release it after that. That's the concern we have about how surveillance works domestically. So a summary on this part based on history, there's a clear history that the erosion of democracies has been accompanied and accelerated by surveillance of domestic political opponents and surveillance of the free press. So extra strong safeguards against such surveillance is a lesson from Watergate, and it's a lesson from the rest of history. And so we have a practical and empirical basis for concluding that strict rules against domestic surveillance support the collective good of rule of law and democracy. And as I said before, this argues that individual rights are better protected if we have extra strict rules limiting surveillance. So that's a summary on that part. Here's a sort of extra point that wasn't in the 3-page outline that I circulated that we're working on now. So one question is, so if we want to have extra strict laws domestically, maybe we should just apply the extra strict laws to everybody. Or that way we could have equality and we're leveling up to a higher level of protection of human rights. That's an idea. I don't think it turns out to be a persuasive idea. So the universalists or cosmopolitans could agree that very strict rules should apply against domestic surveillance and then want the same very strict rules for non-residents. But our view is that these super strict or these equal rules at least won't work over time for foreign enemies and for non-domestic. And so the war zone, the Kandahar example, illustrates the national security need for broader surveillance in foreign settings. There's other non-domestic settings that support that, foreign affairs general. If we tried to impose the super strict rules across the board, then the super strict rules for foreign surveillance, I think, would not be enduring. The national security folks say we can't live under these domestic Fourth Amendment type rules. And then we would get a leveling down. If equality is the rule, we get a leveling down so all the rules are the weak foreign rules. But we still want the super strict for domestic for the reasons said. So basically, I don't think we can keep super strict for foreign. I think it would be a bad idea. It would stop us from protecting ourselves against foreign enemies. So you got to live with somewhat less strict for foreign, but there's reasons to be very strict for domestic. Go ahead.
Well, we still have some protections though, for I know in areas if you are concerned that there are too many U.S. citizens in a specific geographic area, we still have restrictions, right, on what surveillance we can and can't do if we would happen to have too much.
Right. So this will come back to a point that what I'm trying to do in this paper is convince you that two-tier makes sense. And then there would be later work to say exactly in what circumstance, how much two-tier and how broadly does it apply and who counts as a near citizen. So you'd have to fill in all the details. But when we have the global UN leader on this issue going around saying two-tier is immoral and against international law, I want to stop and say, wait a second, there's a really different story than that. If you go with me for that story so far, then at least you're going to have a much more careful conversation and not assume that's the moral high ground. Because I think he's sincere. He thinks he's on the moral high ground, and I think what he was doing would undermine democracy and make a more dangerous world. So I'm glad to engage with him, and we'll get a copy of this when it's ready to show. I'm trying to get it right so that when it's released to the public, people with a really different view, I hope, will say, huh, I hadn't really thought about that. I'll have to go back and think about it. Yeah, Ken.
Do we have, I think you make a convincing argument, do we have effective restrictions on nations trading this information? I mean, a cynic would just say, if the domestic executive wants to spy on Americans, they just have to ask the European country.
Have UK do it for us and we'll do it for them.
Exactly.
That's against the law in the United States.
Okay.
So there's, and having done this NSA review thing, I got briefed to the top secret level, and I know what's available publicly, and it's stated publicly, and I believe it to be true. So it is against the law for the NSA to ask MI6 or whatever or GCHQ to spy on Americans. We can't basically make them our agent to do that. Now, there's times when there's a big data dump, and when it comes from Britain, it hasn't been minimized, and there might be some US person in there, and you have to go around to clean it up. But our rules are you're supposed to clean it up, and you're supposed to suppress the US person stuff. So the legal structure. Here's what I'm tempted to do my last 2 slides and then do more conversation. So for the 2 current controversies, for mutual legal assistance, I think people are going to agree target nationality matters. That's just jurisdiction and choice of law. That provides a really strong basis for greater government access to data where they have a connection to the people they're getting. So the US gets more data about US persons where they have jurisdiction, and they don't get as much data about Kazakhstan. For FISA in Section 702, which is where the European criticism's been so fierce, we have a justification based on national security. We want to target agents of a foreign power when they're outside of the United States. And we have no other way to get data about them but to do electronic surveillance. We can't even do a search warrant. So for that reason, we ought to be able to get that data more easily. And the last slide. This is a previously little examined question of whether different legal rules are lawful and normatively desirable. Positive law shows that the US and other democracies have applied different rules. Normative analysis says there's a good argument for it. Seeking to implement the same rules would undermine valuable protections. And in the name of pragmatism, or the name of protecting individual rights, we try to establish a strong philosophical basis for different and stricter rules for surveillance when it's targeted at citizens or near citizens. Okay, so that's my last slide. So were there other, I'm glad to take general discussion.
Follow up this question. So I mentioned again a foreign power which has a similar stricter rules for domestic surveillance. Foreign surveillance is, of course, very much interested in US politics or in the activity of their nationals in the United States, because they may influence them. So they surveil them, and then even though the NSA or the API didn't request that information, that country very kindly just sends it to US competent agency.
Well, would it be legal or not? If so, some foreign power sends a nice package of helpful stuff about the senators who disagree with the president. Okay, so my understanding of the law would be that if this package just appeared from nowhere, we didn't ask for it, it just appeared, or was sent as a gift, Merry Christmas, that the NSA or the CIA would receive it. And then for the NSA under something called UCIT 18, which is the directive for US person information, they're required to go through it, and they're required to do what's called minimize information about US persons. And so they're supposed to go, and when it says Peter Swire, they cross it out and say US person number 1. And they do that with the data. And then once that's been done, it can go into the system for other uses. So that's what the law says. Another thing is, does the NSA follow the law? People wonder that all the time. And our report found that the NSA had very substantial compliance program that it built up after 2009. After 2009, the NSA added over 300 full-time employees just to do compliance on their electronic signals intelligence. And any mistakes are reported to the FISA court. And the FISA court has declassified a lot of these reports. So you can see, oh, somebody typed in the wrong phone number and they reported it to the judge. Even very small violations have been reported to the FISA court. And so my own view is they have a much more advanced compliance system than almost any company I'm aware of. And so they have the law in place to minimize, and they have a compliance system in place that's automated with independent judges looking over their shoulder for it. And so it's really different, in my view, from the sort of lawless NSA out of control story that was more accurate in the months after 9/11 when they were scrambling to change practices. But 16 years later, they bureaucratized it and put rules in place that are, I think, very elaborate. And in the testimony for this Facebook and Schrems case that's published, if you look for my name online and put in Facebook and Schrems, you'll find it. The oversight and transparency mechanisms, I have a 50-page chapter talking about that. And it's really impressive, and you can footnote it all. And we have a chapter on what the FISA court has declassified since 2013. And it's so different from the starting assumptions of many people that I live in this world where I just read all these pages and I have footnotes on everything about how careful they are. But I know that many, many people think they're cowboys who don't care. But I'll just tell you, having spent a lot of time reading these documents and seeing consequences and seeing the court stop programs when they break the rules, that I've become way more impressed with how careful they are than I expected to be when I got into the field.
I have two questions. So following up on that, I have a different question, but I'm going to ask both. So how confident are you that the review you did during the Obama administration means that the Trump administration can't get around the extent to which it's been bureaucratized, and would we know? And then more generally, I think you make a very compelling, very clear case for the dual tier approach, and I am convinced. But I'm curious what the domestic human rights organizations who work on these issues, like the ACLU, Center for Constitutional Rights, and I don't even know currently what the others at the forefront, what would they say? Yeah. What have they said in response to the UN guys' comment? And that's it.
Yeah. Access Now's commented favorably on it. That's one of the human rights groups that's active in Washington. I'm an optimist sometimes that research and good arguments can help people come to a different view. Nothing like this has been published. In the first symposium I did, it was chaired by Jack Goldsmith at Harvard, who's a well-known international law person, and Ben Wittes, who runs Lawfare blog, was there. And I was asking, have you guys seen this argument made? Has this been out there? They said, no, we've never seen it. Please publish it. So, and they would know. I mean, Jack Goldsmith, among others, had a very senior job in the Bush White House, Department of Justice. And Ben Wittes is sort of like the default national security guru for current debates about such things. So, you know, you can always fall in love with your own argument. I undoubtedly have done so to some extent. But my hope is that people who reflexively thought universalism made sense will now say, if we actually want to have this system work, I'm going to have to think it through more. And they might have 2 or 3 or 5 nuances where my starting point would change some after really smart people think of all sorts of things. But I think that it's discrimination, therefore it's wrong position will be much harder to sustain. And so maybe this begins a more nuanced discussion about where and how much and all that. So that would be great. But I'm delighted that I haven't gotten, I've had very limited people outside my research team see this yet. This is part of why I was glad to come here today. It's the first time I've said most of this stuff, you know, to a group. And it's, these slides were new. I woke up this morning, I had no slides. So these slides happened on the way to Indiana today. You know, okay, so now your other question was, should we trust the current administration? And look, I work for the Obama administration, the Clinton administration. I'm not a fan of Donald Trump. That's not a big surprise, based on my public record and things I've said. Here are some data points. One thing is we still have independent judges doing the FISC, the Foreign Intelligence Surveillance Court. And they get access to all the top secret information. The About collection case, which shut down an NSA collection program, happened this year in 2017 and was declassified. So you have independent federal judges with life tenure and expertise in foreign intelligence who are watching the NSA. And we haven't seen any alarm bells go off from that. So that's good. Another thing is there was this PPD 28, Presidential Policy Directive 28, where President Obama said for the first time that as a principle, we're going to apply privacy protections to US persons and non-US persons where we can, with exceptions where we can't for national security purposes. But as a principle, we're going to strive for that. Some people thought that would get revoked on day one. And it hasn't been revoked. It hasn't been explicitly reaffirmed, but it hasn't been revoked. We would know, I think, if it was revoked, because it goes out to all the agencies. And I think somebody in one of the agencies would tell us if it happened. Another thing we know is that there's a current, like right now in September, review by Europe of something called the Privacy Shield, which is where Europe is actively trying to figure out if the US is living up to its privacy commitments. And as part of that, Europe was very concerned about something with the beautiful acronym of the PCLOB. The PCLOB sounds like a disease, but PCLOB is the Privacy and Civil Liberties Oversight Board. A former Indiana University law professor, David Medine, was the chair of it most recently. The PCLOB didn't have a chairman and didn't have a quorum and couldn't operate. And in the run-up to this discussion with Europe for September, they've named a plausible, smart person to be chair of the PCLOB, which so it's a Rehnquist clerk, but a distinguished, smart person with lots of national security knowledge and stuff like that. So that's a sign of actually having an oversight board get staffed when I think skeptics thought it would never get staffed again. So that's pretty good. You know, this is a question. One way to rephrase your question is, how effective is the deep state? How many limits are there going to be?
Can you please call them public servants?
What did I say?
The deep state.
I would say, Gene, look.
I'll buy another cup of coffee.
I agree with public servants. I have a huge respect for the people I've met in the intelligence agencies who devote nights and weekends to trying to keep, you know, our country and the world safe. And there's people I agree with or disagree with politically on all sorts of things, but the level of dedication that I've seen personally is fantastic. So, and the level of derision they get from friends and family sometimes is unearned in my view. So, in a less flipped way, let me say it this way. We have a lot of established checks and balances in the system. A lot of different things have to go wrong before anybody can call up and say, I want to go after Bernie Sanders, get me stuff now. There's a lot of limits on that. A lot of different people would tell. A lot of compliance red flags would go off. Inspectors general will notice. So at least over the medium term, I haven't seen any evidence of that kind of breakdown. Now, 8, 12, 16 years in, when the same personnel aren't there and those things start to erode, I wouldn't have the same view necessarily. But less than a year in, the evidence is that these institutions are being staffed and people are doing their jobs. That's my best guess based on the available evidence. I worry about it, but it's my best guess. Yeah.
Yeah, and the one thing I kept thinking throughout the entire presentation was the role that bulk collection plays in all of this. Because when I look at the EU arguments, it always feels kind of like the belt and suspenders, throw every argument, see what sticks. But what they really seem to be frustrated about is bulk collection. And I'm wondering if, in your framework, there's a distinction between targeted, where the two-tiered system makes sense, and untargeted surveillance, where maybe a more universalist baseline makes sense.
Yeah. Well, the term bulk collection itself is something people argue over a lot. So one of the things that we know from declassified documents and from Snowden is that part of 702 is called the upstream program. And the upstream program basically is, you know, there's a wire maybe coming into a switching station in San Francisco or some other place, and the NSA attaches a box to the wire and gets everything coming through the line. That sounds like bulk collection. Okay. Section 702 says, and the court has written at length in declassified opinions that this is how they operate. Section 702 says is that bulk collection happens and it goes over to the pre-processing center, and only the very small subset that meets individual selectors goes to any human being. So if Peter Swire is on the list of suspected agents of foreign powers, I don't think I am, but if I were, if the communication is to Peter or from Peter, that meets the criteria, and then the NSA analyst could look at it. Until earlier this year, if it was about Peter, you all said, hey, I saw him speak at Indiana, and then you add your adjectives for whether it was good or bad or something like that. But if it was about Peter, they also could get that communication, but now that's been stopped. Okay. And by the way, you couldn't target me under 702 because it has to be targeted at a non-US person who's overseas. So it'd be like, Pierre Swire in France or something like that. So it's bulk collection at a technical level, but it's only individualized selectors under Section 702. And it's those individualized selectors that have the two-tier, that apply to them. You can't have it at all for US persons. You can have it if they meet the standards under 702. So I'm not sure what other bulk collection you most, did I break it?
No, I'm just going to turn it off so you don't accidentally do something to that.
Oh, sorry. I teach, I move my hands, I walk around. So sorry if I'm wrecking anything in Indianapolis. There were other bulk collection programs. There was Section 215, which is all the phone number metadata of US persons. And that got closed down under the USA Freedom Act, consistent with our recommendations, so that doesn't exist anymore. Now, a different kind of collection is overseas collection. Instead of this being a wire in the United States, now it's a wire that's going between, UK and Iraq or something like that, two foreign countries. And when there's surveillance that happens outside the US, the collection's outside the US, and it's not targeting US persons, there's a different rule. It's called Executive Order 12333. And those rules are more wide open. Because it's foreign-to-foreign communications, there's no reason to think there's US persons anywhere in sight, and we're gathering up bunches of stuff. Now, at that point, the rule is, if we bring this data feedback, I'm not going to use that as my example.
It's off now.
It's off now, I can use it. Okay, so we bring back our CD-ROM drive from 12333 that we got from overseas, and it comes here, that's when we're supposed to minimize US persons. So it was bulk collection under anybody's view. It's under PPD 28, so when possible, we treat everybody the same. But we still have rules that are extra strict for US persons, and we're allowed to apply them. We treat the US persons more carefully, in part, so they don't use it as a backdoor way to look at Americans. That's one of the reasons we do it. Because, US political opposition might be talking to people overseas, and so we conveniently get all their stuff in a foreign-to-foreign communication. So we minimize US persons in part to stop that. So I don't think the bulk collection, would be a reason to stop minimizing US person information. I don't know if I answered your question.
Well, I think when I'm trying to gauge public opinion on what is really bothersome to people, and particularly in the EU, so I'm speculating a lot here, but I feel like it's not even the technical, what we are doing, it's more this nebulous what they can do. And when you say we've got a little switch that we put on the cable and it takes up all the data, but don't worry, we're only looking at a little bit of it.
Right.
Well, you've got the box full of all the data.
No, you don't, because it's never stored. I mean, but then you have to trust us that it's not ever stored. Mm-hmm. And then it's turtles all the way down. You never know, right? I mean, so at some point, and this is a huge problem. This is the fundamental problem of open, transparent, democratic governance of secret intelligence agencies. And that's a genuinely hard problem, because these agencies don't work unless there's secret things they're doing to collect things. If we told them our spy in the Kremlin is Joe wouldn't last long. It has to be secret that it's Joe. And similarly, if we have a tap to Joe's device in the Kremlin, then we can't say the sources and methods, or else they'll close down the tap. So if we're going to get that stuff from the Kremlin, if you think it's legitimate to spy on countries that aren't your country, we can't tell everybody all the details. And then open democracy, transparency folks say, oh, but maybe they're using those tools to really go after the senators and congressmen. And you're like, well, here's the reasons I think that's not true. We have all these laws in place. We have these judges who look at it. We have congressional oversight from Senate and House Intelligence Committees, and they have access to the classified records. We have the Privacy and Civil Liberties Oversight Board, and they can go in and do investigations. And if all of those people are lying, then we're screwed. But we try to come up with ways that reinforce each other so we don't come to the view that they're all lying. That's you know, and the Europeans might just systematically say they're still Americans and we don't trust them until we get our own people in. And then I say, I don't know how to do that. And by the way, you don't let us do it in your country. I don't know. I don't know if that's not fully satisfying, but it's hard.
So I was wondering if the universalists have an argument for handling the situations where we'd be tightening down on sort of Title X force protection capabilities now, because we have a lot more flexibility there too, right? And so suddenly if we're doing this comprehensive rule, we lose, making up a percentage here, but we lose like half of what we can do in Title X.
So the Europeans would like that, you think, to sort of tie the hands of the military?
Well, I'm curious if they would, or if they have an argument, because I assume I assume the European countries have similar aspects that are equivalent to Title X for their own forces.
Okay, so first of all, I'll try to translate that into English. There's three parts of the U.S. Code. There's crimes, 18 U.S.C. Cops have authority. There's the military can do things when they're acting like the military. Title X of the U.S. Code governs that. So Title X authorities is what the U.S. military can do, for instance, in Iraq and Syria and Afghanistan when they have powers to act. And then in between is Title 50, which is intelligence authorities, what the NSA can do. And most people who aren't in the military have never really thought about what you can do under Title X. Are you with the military?
Yes.
I mean, you pretty much knew that. Okay. So what you can do under Title X, which is very broad authorities because people are going to die and we really want to know whether the IED is going to go off, that's Title X. Title 50 is more restrictive, and Title 18 crimes is even more restrictive. So we had a panel on information sharing for law enforcement, intelligence, and military purposes. That's online at our Georgia Tech website about this cross-border stuff. And we had the former Supreme Allied Commander NATO on the panel talking about how it really works in Europe and stuff. So that might be of interest to you, because as far as we can tell, there's never been a panel talking about how these systems interact for purposes of this foreign intelligence surveillance stuff. But the Kandahar example, to me, would be persuasive to a European military person who would want to talk to their civil liberties folks and say, you're nuts. We need power in the war zone. We're not going to go through the GDPR, that's the new privacy rules in Europe, when it comes to fighting a war and having our people blown up. We're just not going to do that. And I'm sure the military people in Europe know that, but they're never in the same conversation as the privacy absolutists are. And so one hope for this research is to make people who are used to being in human rights discourse concretely say, no, let my son blow up in Kandahar. It's a really mean rhetorical trick. Do you want my son to die? Yes, I believe in human rights that much. It's a really unfair rhetorical trick, and I'm going to stick with it. That's why I put the personal note in.
Effectively, what would, in some ways, that's effectively what would happen, given the information that's required to run the counter IED.
Right. Right. So you try, you take a situation factual, and then if the people who are not inclined to agree with you want my son to die, that puts them in a bad place. If they agree we have to have different rules there, they've opened the door to having different rules for all these other purposes. So that's the choice that the unfair rhetorical trick is meant to pose to them.
Maybe one more question.
One more question.
FISA court question, a short one. So the Chief Justice appoints all the judges to the FISA court, correct?
Yes.
As a structural matter, not as a critique of Chief Justice Roberts, would you believe that the FISA court would be better staffed if you have the three most senior Supreme Court justices instead of having just one person appoint all the judges in the FISA court?
Yeah. So Chief Justice Roberts got harshly criticized for his selections, and that came out during the Snowden period. And the next two selections were Democrats. judges appointed by Democratic presidents after every other one had been Republican. So that became a flashpoint. The review group report had a recommendation on that that wanted to change the structure. I didn't dissent from it, but I'm not convinced that Chief Justice of the Supreme Court is that much of a problem. So when you open up a box and you start to change things, are you overall going to get something better? I hope whoever's Chief Justice of the Supreme Court can play a role in administering the U.S. judiciary. Putting layers on that is not my favorite thing, but if it's a bad enough set of historical facts, at some point you consider changing it. And people have reached different judgments about how bad the history is versus how messy it would be to sort of interfere with administering the judiciary. So I can see both sides, but I'm a little more cautious than some people who've wanted to make that change. We're working on edits. I'm easy to find by email. If any of you have comments, questions, things that weren't clear, suggestions for further research, I'd really appreciate it. We're trying to get this thing done in the next couple of months. So thanks very much for your attention.